Just one or two things. Minister McGrath couldn't be with us this morning, but Minister Catherine Zappone will be with us tomorrow. She is the Minister in our new government on youth and children. And you may have noticed in the hall that we have an art exhibition. The art exhibition is on Article 12 of the UN Convention. It's, I think, 16 scenes about emerging from the darkness of guardianship into freedom, autonomy, and supported decision-making. So Minister Zappone is going to formally launch that right after your proceedings tomorrow, 5:15 thereabouts. And Pavletta, is Pavletta here from BCNL? No. Pavletta is going to say a few words about how that art was commissioned. It was commissioned by the Center for Non-Profit Law in Sofia in Bulgaria, and the artist and the centre very kindly lent it to us. And all of the seats will be taken away, the tables and so forth, so you can enjoy the formal launch tomorrow. Just one or two brief things about this afternoon, and then JB will do some housekeeping announcements. The idea was to give you at least a basic grounding in what a treaty is, how to interpret a treaty correctly, and how in particular to view the many declarations, reservations and understandings that pockmark the treaty, in fact pockmark any treaty in the UN system. And for that we're very honoured and privileged to have with us the legal advisor to our foreign ministry, James Kingston, who's a great friend of this summer school. And then Rosemary will follow up by describing to you from a lawyer's point of view the key features, the salient features of the UN Disability Treaty, not only the rights but also the obligations. So GB, do you want to talk to them about more practical stuff?
No, I'm actually going to do that.
Okay.
So the practical stuff is, no matter what happens, we're going to be in the breakout rooms by 4 o'clock. So at 5 to 4, Professor Quinn is going to talk to us about the concept and how it's going to work at 5 to 4. Now, also, I want to let you all know that the Radisson, the barbecue inside is, how to get there is on the back of your programs, or you can find out by asking anybody around the place in terms of how to get to the barbecue. Everybody, as Professor Quinn has already said, is more than welcome. But you must find your own way there and find your own way back. And different people will give you different tips on how to do that. So, but there is no organized transport per se. So right now, I'm going to hand over to James in terms of giving us an overview of treaty, etc. If that's okay. Thank you, James.
Thank you, Mark. So, thank you very much. Can everybody hear me? Yeah. Okay, well, first of all, thank you, Mr. Chair, and thank you, Jared Quinn and colleagues from the Centre for Disability Law and Policy for the invitation to speak with you all today. This is the second time I've spoken at the summer school, and I was delighted to be invited back. I should just say that I'm speaking here in a personal capacity and not on behalf of the ministry that I work for, the Department of Foreign Affairs and Trade. But I'm pleased to be here for a number of reasons, because the summer school always draws together a very interesting group of people, including Rosemary, and it's a great privilege, Rosemary, to be asked to speak on a panel with you again for the second time. And thanks, as I say, in particular to Jared, who I first met in 1989, at a time when you can tell we were both very young indeed. But over the years, I've come to know Jared well, and as well as being one of the world's leading experts in disability law, he's also great fun to be with. Since we first met, we've come across each other in a variety of different guises, including during the negotiations that led up to the conclusion of the UN Convention on the Rights of Persons with Disabilities, in which Gerard played a leading role. For me, working on the convention was particularly rewarding, in large part due to the extensive involvement of civil society and independent experts, and most importantly, of course, people with disabilities, along with the usual government delegations. So I'd like now to turn to the topic on which I've been asked to speak to you today, and I'm afraid it's a rather technical topic on treaty law and rules of interpretation, with a particular focus on reservations and declarations to the Convention on the Rights of Persons with Disabilities. I've been asked to speak for about 20 minutes. Now, I don't have any PowerPoint today, but I did post a series of questions and readings to consider on the school's website last week. It contains an imaginary set of reservations and declarations from the state of Narnia. And later on, we're going to look at the particular statements that have been made or proposed to be made by Narnia and see whether we think they comport with international law rules on reservations and declarations. And I also have a paper which is going to be posted on the summer school website later. So I'm first going to talk briefly about the law of treaties in general. Secondly, we're going to look at the rules of interpretation of treaties. And thirdly, we'll look at the rules relating to reservations and declarations. We can then look at what the Convention itself says about reservations and declarations, what the Committee on the Rights of Persons with Disabilities has said, what reservations and declarations have been made by states parties, and what others have said about those reservations and declarations. And we're going to focus in particular today on reservations and declarations to Article 12 of the Convention, which, as you may know, deals with the very important issue of equal recognition before the law. So, as I said, the law of treaties is a very technical topic, dealing with matters such as how to adopt the text of a treaty, who may sign and ratify it, how treaties are to be interpreted, and what is to be done when states disagree over interpretation. The principal treaty dealing with the law of treaties is the Vienna Convention on the Law of Treaties of 1969. So, looking at treaties, the first question to consider in treaty law is, what exactly is a treaty? And this is defined in Article 1 of the Vienna Convention, the text of which is contained in the appendix posted to the website last week. So a treaty is an international agreement between states or between states and intergovernmental organizations governed by international law. So it's similar to a contract in some ways, similar to domestic legislation in others. And it's one of the main sources of public international law. The next question to look at is how a treaty is to be interpreted. Because as with the domestic law rules of statutory interpretation, which some of you may be familiar with, international law has its own rules with respect to the interpretation of treaties, which are set out in Articles 31 and 32 of the Vienna Convention. And the text of those articles is also in the appendix to the paper. So the basic rule is that the terms of a treaty are to be interpreted in good faith in accordance with their ordinary meaning, in light of the overall object and purpose of the treaty and its context. And the context comprises the text of the treaty as well as other related international agreements and instruments. But then, as well as the context, subsequent agreement and practices of states that are party to the treaty may be relevant to how we interpret it. So what states do is relevant. If the basic rules of interpretation give rise to a situation where the terms of the treaty are ambiguous or obscure, we can then look at supplementary rules of interpretation to try to clarify the meaning of the treaty. So, for example, we look at the preparatory work leading up to its conclusion, such as reports of discussions and negotiations. I think it's important to say that the Vienna Convention was concluded at a time when UN human rights treaties were in their infancy, and therefore no mention is made of the role of UN human rights treaty monitoring bodies, such as the Committee on the Rights of Persons with Disabilities. But they do have a particularly important role to play in modern human rights law. And although their interpretation of treaties is not binding, it is authoritative and important, and states and others should have due regard to what the committee says about the treaty. So just turning to look very briefly now about reservations and declarations. And the first thing to look at is, what is a reservation? And this is defined again in the Vienna Convention, and again the text is set out in the appendix. But essentially, a reservation is a statement made by a government when becoming party to a treaty, which purports to modify or exclude the legal effects of one of the provisions of the treaty. So a state is reserving for itself the right to derogate from the rules of the treaty. A declaration is something that is slightly different. A declaration may mean a number of different things, but one example is that a state may make a declaration when ratifying a treaty, saying that it interprets the provisions of the treaty in a particular way. So it's not saying it's claiming an exception, it's telling states and others how it interprets the provisions of the treaty. And occasionally it can be difficult in practice to know what is a reservation and what is a declaration, because states sometimes use the terms interchangeably and incorrectly. And the important thing to look at is what is the substance of the statement rather than the label that has been put on it. So generally, a state can make a reservation to a treaty unless the rules in the treaty say that it can't, and some treaties do say that no reservations are permissible. But the general rule is that a reservation can be made so long as it isn't contrary to the object and purpose of the treaty. But by the same token, other states can object to reservations and declarations made by other states, although they generally don't do so unless they think that they are contrary to the object and purpose of the treaty. We'll come on to that in a moment. So before turning to look at the legal effects of reservations, I suppose I should say that contrary to some perceptions, not all reservations are bad all of the time, even when they're made in the context of a human rights treaty. And this is because sometimes a state may wish to become party to a treaty, particularly an important one such as the Convention on the Rights of Persons with Disabilities, but it may know that it's not currently in a position to meet all of the obligations contained in the treaty, or it may disagree with some specific provisions. And in such circumstances, it may be better for it to become party to the treaty with reservations and declarations, rather than not ratifying at all. So just with particular reference to human rights treaties, reservations that are contrary to the object and purpose of a human rights treaty are reservations that are very far-reaching, so that a state that makes a very broad reservation can't be said, properly speaking, to be accepting the obligations contained in the treaty at all. So in the words of the International Law Commission of the United Nations, a reservation is incompatible with the object and purpose of a treaty if it affects an essential element of the treaty that's necessary to its general tenor or is contrary to the very basis of the treaty. And one example of such a type of reservation is one that says that a state is accepting the obligations in the treaty subject to a system of law such as its own domestic constitution or the rules contained in a religious code such as Sharia law, rather than subject to international law. And the issue of reservations is particularly important in human rights treaties as compared to normal treaties. And this is because, unlike in the case with normal treaties, which deal solely with the obligations and rights of states, Human rights treaties deal with the rights of people, of individuals, and therefore it's not acceptable to compromise on the rights of individuals in the same way that you might compromise on the rights of states, for example, in a field such as law of the sea. Now, I go into some even more boring and technical detail in the paper, but I won't keep you too long with it now. So states that are party to a human rights treaty have the obligation to make as few reservations as possible and to regularly review them. And they also have a duty to examine the reservations of other states and to object to them if appropriate. Now, this may not be necessarily required, legally speaking, but it is an important political signal to the international community, and in particular to the persons whose rights are supposed to be protected by the Convention. And one of my jobs in my day job is to participate in various groups in the EU Council of Europe that look at treaties and reservations to them with a view to objecting to those that are incompatible with human rights, for example. So now, after this very lengthy, I'm afraid, preamble, let's look at how the rules that I've just discussed apply in the particular context of the Convention on the Rights of Persons with Disabilities. So we're just going to look briefly at what the Convention says, then look at what the committee has said, and then look at particular reservations and declarations made by states parties to the Convention, with a particular focus on Article 12. As I think I may have mentioned already, the Convention doesn't contain any special rules and reservations. It simply provides that reservations must not be incompatible with the object and purpose of the Convention. Now, notwithstanding this permission in the text of the Convention, the Committee on the Rights of Persons with Disabilities has asked all states to ratify it without reservations or declarations. And if they are made, states are asked to justify and explain them when making periodic reports to the Committee on their implementation of the Convention. And the Committee will then make comments when it is making its concluding observations on the reports. So looking now at the specific reservations and declarations to the Convention. The Convention has 160 signatories and 165 states parties. Over 30 of these states have made one or more reservations or declarations, although happily a couple of these have already been withdrawn. Now, in view of the large number of states parties to the Convention, this number of reservations and declarations isn't unusual. So when considering reservations and declarations made to the Convention, we're going to look first at some that have attracted negative comment from other states, and then others that have not, as well as looking at comments made by the Committee. And finally, we're going to look briefly at the statement made by the imaginary state of Narnia. And all of the reservations and declarations to the treaty are set out in the website of the United Nations Treaty Law section, and I gave that reference in the appendix that was posted on the handout last week. So one example of a reservation that's been objected to by several states is one made by El Salvador when it ratified the Convention in 2007, and it subjected its acceptance of the obligations under the Convention to its domestic constitution. So this is typical of the type of general reservation made to treaties that is not permissible, and it was objected to by a small number of other states parties to the Convention and by the Committee when it looked at El Salvador's first periodic report. And now that reservation has been withdrawn, but a similar statement by Iran remains. So looking now at reservations and declarations that have not attracted a huge amount of commentary from other states, with a particular focus on Article 12. So as you'll be aware, Article 12 deals with equal recognition before the law, and it affirms that persons with disabilities have the right to recognition as persons before the law. It requires states to recognise that persons with disabilities enjoy legal capacity on an equal basis with all other people in all aspects of life. Article 12 also requires states to take appropriate measures to provide access by persons with disabilities to such support as they may require in exercising their legal rights. Paragraph 4 provides for appropriate and effective safeguards to prevent abuse and to ensure that the rights, will and preferences of persons with disabilities are ensured. States are also required to prevent conflict of interest and to ensure that any safeguarding measures are proportional and tailored to the person's circumstances. And those measures must apply for the shortest time possible and be subject to regular review by a competent, independent and impartial body or a court. And Article 12 also makes provision in relation to property and financial matters. Now, of course, it's true to say that all rights are important, but Article 12 is, I think, particularly key because the effective exercise of so many other rights depends on recognition of legal capacity. And Eleanor Flynn has in fact called it one of the main catalysts for change in international human rights law. The article was the focus of intense debate during the negotiations leading up to the conclusion of the Convention and has attracted some 11 statements from states becoming party to the Convention, both reservations and declarations. Now, a particularly key issue during the negotiations in Article 12 was the replacement of forms of substituted decision-making, such as full guardianship, with supported decision-making. And there were different views expressed as to the permissibility of substituted decision-making. During the negotiations on the treaty, the group of Arab states, for example, expressed an understanding that Article 12 of the Convention referred to capacity to acquire rights, but not the capacity to perform them. Although, of course, this exception did not make it into the text of the Convention, the final text. Nonetheless, a number of states, such as Syria, Egypt and Kuwait, have made reservations that essentially take the same view as was expressed by the Arab group during the negotiations. And indeed, non-Arab states have also made reservations and declarations on capacity, including Estonia and Poland. Although, interestingly, when Poland made its first periodic report to the Committee on the Rights of Persons with Disabilities, it indicated that it may be moving away from this model of decision-making. Now, there's a couple of other types of reservation I'll mention very briefly in relation to Article 12. Georgia, for example, made a statement on the need to interpret Article 12 in light of other human rights instruments and its domestic law, with a view to conferring the highest degree of legal protection for safeguarding persons with disabilities and their property. Now, I know we have some colleagues from Georgia here at the summer school, and it will be interesting to hear their views on whether this declaration is intended to confer extra autonomy on persons with disabilities or whether there's perhaps a more paternalistic impulse underlying it. Now, just to mention briefly also a declaration made in similar terms by Australia, Canada and Norway. They all say in interpretive declarations to the Convention that they think Article 12 permits fully supported or substituted decision-making as a last resort and subject to appropriate safeguards. And indeed, Canada has also made a reservation in case its interpretation is incorrect, reserving the right to use substituted decision-making in those circumstances. There's a couple of other reservations, but time doesn't permit me to go through them. But importantly, you will wish to be aware that the committee has issued a general comment on how Article 12 of the Convention should be interpreted. Now, I should say that the general comment has caused some controversy. Not everybody agrees with it. Some people think it goes too far, and other people think it doesn't go far enough, which is perhaps as good a range of criticisms as one could hope for. But importantly, in the general comment, the committee says that supported decision-making should never amount to substituted decision-making. And it says that states parties are, in its view, not permitted to maintain substituted decision-making. And the committee also looked at Australia's interpretive declaration that I mentioned a moment ago, when Australia made its first periodic report to the Convention, and it asked Australia to review the declaration with a view to its withdrawal. So now, just briefly to sum up, we have looked so far at the law of treaties, including rules of interpretation and reservations and declarations, and have had a brief look at the reservations and declarations made to the Convention on the Rights of Persons with Disabilities, with a particular focus on statements relating to Article 12 of the Convention on Equal Recognition Before the Law. So I guess it's time now to look at the question for discussion that was posted to the school's website last week. But before, and I'd be very interested to hear your views on the compatibility or otherwise with international law of this proposed statement by the imaginary state of Narnia. But before I do that, I guess I should ask if there are any questions or comments that anybody has at this stage. Thanks, Mark.
Thanks for that great presentation. I had a quick question that came to my mind when you were talking about El Salvador and the example of the general reservation. I was quite surprised to hear that the general reservation was challenged only at its product review at that point. Is there no process of before, upon ratification, where the states signal that these are going to be the reservations and that the committee or other bodies, state parties can challenge it at that stage already, any reservations? So just that kind of struck me. That's what I wanted to
Okay, thank you. Just let me respond very briefly to that. Sorry, I did mean to say in the paper, but perhaps I went through it too quickly, that in fact a small number of states had objected to that reservation. The rule in the Vienna Convention, the law of treaties, is that when a state makes a reservation, other states parties to that treaty have 12 months to make an objection. And in fact, a small number of states did. And as I say, very happily, then the committee said what it had to say, and happily El Salvador decided to withdraw this reservation. Thank you.
My name is Zahid Abdullah and I'm from Pakistan. Thank you very much for excellent presentation. I have this question, but let me give you a brief background with regard to Pakistan is a signatory and Pakistan has ratified this disability treaty. And a couple of years back, there was this case filed in Supreme Court of Pakistan. I won't bore you with the details, but I wanted to be a party in that case. So I filed, paperwork and all that stuff. And the registrar office, this is with regard to Article 12. They said that, Mr. Zahid Abdullah, since you can't see, so you cannot be, it was not disability related case. It was transparency and right information related thing. So they said that you cannot represent yourself because you are a blind person. So they said that, you either hire a lawyer or a friend who will be submitting on your behalf. I stood my ground. I said that, since I had seen this article and I've been watching this disability debate as well. So I stood my ground and I said that, this is discrimination. And so I asked the registrar office to put it in writing that I can't submit myself before Supreme Court just because I cannot see. So he gave me in writing and I filed again a petition to the Chief Justice of Pakistan, and I also highlighted, it was a major news in the newspapers next day that the Supreme Court is disallowing a person because he's blind. So anyway, I never heard from the court, so this was violation of this Article 12. So my question is whether, if there is this kind of violation, I know civil society groups can raise their voices in front of the committee, but can individuals do that, and what is the procedure for that? Thank you.
Okay, well, thank you very much for that question. And congratulations to you on standing your ground. I should say that Pakistan is a state party to the convention. I'm not, I'm afraid, sure if Pakistan is party to the optional protocol to the convention. But if it is, then it is possible to make a complaint to the Committee on the Rights of Persons with Disabilities, either on your own as you have done, I think probably so ably defended yourself so far, or else with the assistance of a lawyer. If Pakistan has not yet ratified the optional protocol, then you can't appeal directly to the committee, but it is possible to inform the committee of the position that you find yourself in, either directly or perhaps through civil society representatives. And then that issue can be considered by the committee when Pakistan comes to present a report to the committee on how it is implementing the convention.
Okay, I might hold the other questions to the end, if that's okay, because thank you very much, James.
Okay.
I think he's made. Oh, have you more to say?
I just have a couple of things.
Okay,
We're supposed
sorry.
to be doing a very brief class exercise,
no.
so I'll just go through that
Go
very
ahead,
briefly.
sorry
will I?
about that, yeah.
Okay, and I say apologies for not having a handout. But basically, the question for discussion, which is posted on the website, is a statement proposed to be made by an imaginary state before it ratifies the Convention on the Rights of Persons with Disabilities. And there are 4 statements, and the exercise is to go through each one of the 4 of them. Now, we may not get through all of them this afternoon, but it's something to think about perhaps later in the week or as you travel home. So I'll just mention the first of the 4 statements now and then briefly look at the other ones. So the first statement that this imaginary state makes is that it says that Narnia will implement the provisions of the Convention in accordance with its own constitution and domestic law. And as I think I've explained in my talk, that sort of a reservation is in fact not permissible. Now, the second statement, and let me quote it, is that Narnia interprets Article 12 of the Convention in conjunction with relevant provisions of other international human rights instruments, and will therefore interpret its provisions in a manner conferring the highest legal protection for safeguarding the integrity of persons with disabilities. Now, this is similar to the type of reservation, not identical, but similar. This interpretive declaration is similar to that made by Georgia and also Venezuela. So just wondering if anybody has any comments on that. No, as I mentioned in the paper, you have to look at a statement like that, try to work out what it means in practice and whether it in fact extends rights or perhaps restricts them. The third statement that I make is basically similar to the ones made by Australia, Canada and Norway. And in that, the imaginary state of Narnia says that it recognises that persons with disabilities enjoy legal capacity, but that it understands, it interprets the Convention as permitting substituted decision-making arrangements as a last resort and subject to safeguards. And then finally, there's a reservation stating effectively that if that interpretation is an incorrect interpretation of the Convention, it has the right to derogate from that particular provision. So does anybody have any questions or comments either on those statements, or if the Chairman will allow me perhaps 1 or 2 other questions?
Up here to the right, Professor Quinn.
So, thanks, James. I'm wondering, what's your instinct, not as the legal advisor to the Irish Foreign Ministry, but as a legal advisor, if there was a provision in the Disability Treaty that either on its face or in the interpretation put on it by the treaty monitoring body that runs directly counter to an equivalent provision, let's say in the Civil and Political Rights Covenant, how do you go about figuring out what's your primary obligation as a state? Is it to the CRPD or is it to the Covenant on Civil and Political Rights?
Okay, well, thanks, Gerard. And that raises a very interesting question. Now, the Vienna Convention on the Law of Treaties says that you have to look not only at the treaty itself, but if there's any question mark about it, you have regard to other rules of international law. And in one of the declarations that I mentioned, the one made by Georgia, there is an attempt by that state to reconcile international obligations that may, on the face of it, run counter to each other. So there's no easy answer to that question. You could say that this convention, the Convention on the Rights of Persons with Disabilities, essentially takes the human rights contained in both the Covenant on Civil and Political Rights and the Covenant on Economic, Social and Cultural Rights. It updates them and modernises them. And I think Rosemary had said it's a fiction to say that there's nothing new in the Convention. There is, I think, there are some new rights, which particularly relating to, for example, assistive technologies, which simply weren't to the forefront of people's minds when the covenants were drafted in 1966. So you try and reconcile the provisions of this convention with the provisions of the covenant. So where it's possible, you reconcile them, but I guess if there is a particular provision in this convention that appears to say something that is different to what the covenant says, then you try and give effect to the specialised rule contained in this convention, which was drafted later in time and specifically with the rights of persons with disabilities in mind.
Okay. The gentleman here beside Christy Lynch. Sorry. The microphone is coming. And then one last question at the back.
Thank you very much. My name is Mohannad. I'm from Jordan. I'm a senator, and I'm chairing the legal committee, which is responsible to draft a new law on the rights of persons with disabilities. What I would like to say, actually, first of all, thank you very much for this very informative presentation. And what I want to say with regard to reservations and declarations, that it's a very critical issue because Article 12 in particular, as you correctly mentioned, it's one of the core provisions and articles, in particular when we are talking about the legal to act, because putting any reservation, it means that they took away or they take away your legal tool in order to exercise and to enjoy your human rights on an equal basis with others. And with regard to the Arab states, I was there in the United Nations, and it was a very sad moment when I was listening to their opinion, and I would say the majority of their opinions, in particular for the representatives of Arab delegation, it came out of kind of ignorance in both in law and in Islamic law as well. However, my last point about the reservation issues, I think there is another point: who is deciding and what are the standards to decide if a particular reservation, for example, is against or in contradiction with the purpose or the objective of the CRPD. Sometimes it seems a little bit subjective. Maybe everybody has his or her own opinion. I think the convention in this regard must be perceived as integral, document. You need to look at Article 3, General Principles, Article 4, and the whole convention to see if a specific reservation really is contradiction with any of those, because all of these articles, to me, represent the objective and the purpose of the convention. I would like to hear your opinion, for example, about it, what is seemed to be less dangerous reservation, but for me it is still, dangerous, which made by UK, for example, on Article 24 on education. And to me, when I see that this reservation is contradiction or in contradiction with Article 3, which includes a basic or general principle on inclusion, I think this is something deserves to be, objected against, or at least to be discussed more feasibly. Thank you very much.
Thank you. Just, I might go to the last question as well at the back.
Thank you. I thought it would be interesting, if it's at all possible in the timing, to hear from Senator Harkin or John Wodach or Judy Heumann about the issue of reservations, understandings, and declarations in the process of ratification or towards ratification of the CRPD in the US. because I think there have been some very interesting discussions around RUDs in the United States on the CRPD and indeed on any international human rights treaty.
Okay, I'm going to hold that one because, in fairness to the speakers here, and we might take you, Tom, just before we go for tea break. Okay? Where's John? Okay, no. Okay, right. Well, look, we leave it at that. Do you want to, first of all, comment on the last question here?
Well, thank you. I'd like very much to be here for the comments by John, but unfortunately I may have to run off before them, so I'll be emailing you looking for your views. But thank you very much to the Senator from Jordan for his remarks and for particularly putting his perspective on the comments of the Arab group. Now, there was a specific question with regard to a reservation made by the United Kingdom, but unfortunately, even though I'm not speaking on behalf of the Department, I think, of Foreign Affairs and Trade of Ireland, I think it would perhaps be a little invidious for me to make a specific comment on a reservation made by another state party. But I should say that Ireland, my government, does take very seriously its responsibility to look at reservations to treaties. And when Ireland, in the coming months, I hope, ratifies the convention, we will be looking at existing reservations and declarations made by other states. But you touched, Senator, on a very interesting point about who may interpret the provisions of a convention. Now, there's a question of the technique that anybody employs, and as you say, you must look at all the provisions of the convention taken together. It's also important to look at its preamble, the discussions, the negotiations, general international human rights law, look at the meaning that best gives effect to the provisions of the convention, but bearing in mind the importance of getting states to ratify international agreements. There's a basic rule of international law that international law is binding on states only to the extent that they consent to it being binding. Now, that may be, in the view of some, an unfortunate feature of international law, but that is the very basis of international law. And therefore, it is important to have some flexibility for states when ratifying a treaty. And sometimes it may perhaps be more, I wouldn't like to say honest, but it may be more transparent for a state to make a small number of reservations and declarations to a treaty when ratifying it, rather than to wait for some years until a problem is identified, for example, in a periodic report. But the simple answer to the question, who may interpret a convention, is that in a convention such as this, there is no single body that interprets it. The views of states parties to the treaty are an important indication of how they regard the treaty, but similarly the views of the committee are important. But even though the views of the committee are important and authoritative, they are not determinative. And that is because the states parties, when concluding the treaty, did not give the Committee on the Rights of Persons with Disabilities the same authority as a court to make binding rulings on its provisions.
Okay, thank you very much again, James. We're running a little over time at the moment, and I just want to check so that we won't be interrupting Rosemary. If we can go straight through until about 3:45 and then come back for, we'll go to the rooms then after that. Okay? So, Rosemary, we have just about 44 minutes or so. Are you all set? Yeah. By the way, if we do get chances for questions, I want you to keep your questions tight, okay? And we'll give you your own platforms another time. I think Rosemary's almost been here for every school. Some of us think it's Rosemary's summer school we come to. Yeah, okay.
Yeah, that's better. Can you get it back up on my ear, please? I don't know about Rosemary's Summer School. I haven't been here for everyone. It might just feel like it's Rosemary's Summer School. Okay, I'll apologise now that I'm not going to get through everything since it's all been so exciting and interesting this morning and we're running a wee bit over. But you might actually think it a blessing that I've got about half the time to get through my stuff. We'll see how we go.
Do you remember the name of it?
That's it?
That's it, okay.
Okay, we can go straight to the next one, thanks. All right, this afternoon what I'm going to do very briefly is give a brief introduction to CRPD. I want to talk very briefly about the overview, what its content is in terms of target group structure, interpretation and the underlying themes, underlying policy and major themes. And then I want to pick up on something that James spoke about and that the Jordanian minister talked about was the cross-cutting obligations and levels of standards of state party obligations and other general cross-cutting obligations, and then speak very specifically about obligations around CRPD and recognised human rights and fundamental freedoms. I will try not to go too quickly and I will try not to truncate too much, but as you can see, there's a bit of stuff to get through and I would like to leave some time if anybody's got any questions. I'll apologise now, I will move around. The PowerPoints aren't necessarily for you. I don't mind you looking at them, but basically they're for me. And the lectern is not very, over there behind the lectern, it's not very accessible to me. So we'll see how we go. All right, next. So, as you all know by now, CRPD is a human rights treaty. It was adopted by the United Nations General Assembly in 2006, and its purpose is to promote and protect the rights of persons with disability and ensure that these rights are fulfilled. It also aims to promote respect for the inherent dignity of persons with disability. It has a sister document, a sister instrument, the optional protocol. Now, this is a separate treaty, and it allows individual communications to the CRPD treaty body about CRPD rights violations. And it allows the treaty body to conduct inquiries on grave or systemic violations to CRPD rights. Because it is a separate instrument, it means that countries can be states parties to the treaty, but not to the optional protocol. So there are states that are states parties to just the treaty, but not the optional protocol. And there are also states that are states parties to both the treaty and the optional protocol. Those that have ratified both instruments have elected to accept the jurisdiction of the UN CRPD Committee on the Rights of Persons with Disabilities. Okay. Now, the typology of the CRPD as an international human rights instrument is understood as a comprehensive or a hybrid human rights treaty. That being that it incorporates both social development and non-discrimination and other human rights subject matter. So it's a treaty that sets out specific prescriptive development content for states parties to meet as international norms, but also frames it within the framework of non-discrimination as a legal standard. So the treaty incorporates both civil and political rights, as well as economic, social and cultural rights, and arguably some new classes or types of rights. That is not to say that CRPD introduces specifically new rights just for people with disability. That is not what we're saying when we're saying that it is arguable that there's new classes of rights. It's just that it covers areas of rights or interpretations of rights that haven't been addressed before. It's a thematic convention in the sense that it deals with the human rights concerns of a specific population group, namely people with disability. Next. Okay, the status of the CRPD. So it holds exactly the same status as all other core international human rights instruments. Now, they're referred to as core human rights instruments when they refer to a human rights instrument that has an aligned treaty body. So it has a treaty body, so it is recognised as a core human rights treaty. So it holds the same status as the International Bill of Rights, and that is the suite of rights of general application. So the Universal Declaration of Human Rights, the International Covenant on Civil and Political Rights, and the International Covenant on Economic, Social and Cultural Rights. It also has the same status as the other thematic human rights treaties. So the other treaties that are based on thematic population groups, such as the Convention on the Eliminations of All Forms of Discrimination Against Women and the Convention on the Rights of the Child. And what this means is that for the first time, human rights of persons with disabilities are of central importance in international efforts to promote, protect and fulfil rights. So the rationale for the CRPD, which goes a lot to the way we read and understand the content of CRPD and also interpret CRPD, is that it was developed because of international concern that the existing human rights instruments had failed to effectively protect the human rights of persons with disability, even though they have always applied to persons with disabilities on an equal basis with other persons. So through the instruments of general application, people with disability were covered through the International Bill of Human Rights and through especially the two covenants, under the scheme of other status. So under other status, disability had featured prominently in the jurisprudence of both especially the Human Rights Committee. So it wasn't as if there wasn't a focus on disability, it was just that there wasn't a dedicated instrument around disability. And what CRPD has tried to do is it's tried to overcome this problem by ensuring that persons with disabilities are now highly visible rights bearers. It also tailors and applies traditional human rights to some of the specific human rights problems of persons with disability. And it's also focused at building capacity in human rights implementation efforts to effectively respond to the human rights of persons with disability. So it's about focusing efforts on the implementation in understanding the issues that people with disability face and building capacity within existing traditional human rights infrastructure to be able to address issues around disability. Yep. So what's its relationship with other instruments? All other human rights instruments continue to apply to persons with disability on an equal basis with other persons. So the Convention on the Elimination of All Forms of Discrimination Against Women continues to apply to women and girls with disability on an equal basis with other women and girls. So therefore, CRPD must be implemented in an integrated way with other human rights obligations. So this gives rise to two related implementation concepts, a twin track approach and a mainstreaming approach. So the twin track approach is where you have a dedicated focus on an issue, such as disability, within a women's framework, within a gender framework, and then you interrelate it broadly through that. So you have the vertical of recognising the specific issue, say disability, within a broader women's context, and then a vertical of integrating disability into that whole gender framework. As well as a mainstreaming approach, so that's getting disability into mainstream infrastructure. So it's just one aspect of any framework. And generally speaking, the CRPD supersedes earlier non-binding disability human rights instruments. So the instruments that have come before CRPD that were disability specific, and all of them were non-binding, so the two earlier declarations from 1971 and 1975, along with the programmatic work that happened through the 80s and 90s, the CRPD supersedes these instruments. So, international human rights law is persuasive. It's based upon solemn ethical commitment of states parties. The state itself must commit to action to resolve violations. It's a kind of ethical contract between states and the community of nations. CRPD requires states parties to lodge a baseline and periodic report outlining compliance with CRPD rights and progress towards their attainment. So shadow reports from national human rights institutions and non-governmental organisations are also considered and may result in concluding observations and recommendations for actions to improve compliance. The CRPD optional protocol also allows for individuals and groups of individuals to communicate with the treaty body if they believe their CRPD-based human rights have been violated. Now, there is very strict rules around the admissibility of complaints or communications to the treaty body. So first, there must be an exhaustion of all reasonably available domestic remedies. The issue at hand, talk about articulate. The issue must relate to conduct that has occurred or has continued since the CRPD entered into force with respect to a particular state's party. So if a country ratified in 2008, the conduct must have occurred after that ratification, or must have, if it started earlier, it must have continued to occur after that ratification. And these communications may also result in recommendations to resolve violations, although injunctive relief may be requested. The CRPD treaty body may also conduct inquiries into grave or systemic violations of CRPD rights, and this may also result in recommendations to resolve violations. So the way the committee works with states parties is to create a create a dialogue, conductive I wanted to say, but that wasn't what I was supposed to say, to create a constructive dialogue. It could be conductive, but I don't know. Constructive dialogue with states to find ways to problem solve so they can address the violations and come up with solutions. I've got a technical difficulty with a droopy ear. It's falling off on one side.
Oh.
I'm no Madonna of the headset. I may be old, but I don't have her moves. All right. So, this is one of the hotly debated points. People trot out the definition of disability. I'll say it once. Actually, I'll end up saying it about 6 times, I'd say. But I'll say it once for you here and now. There is no definition of disability in CRPD. Absolutely none whatsoever. You can search until the cows come home. You're not going to find one. What they do after much debate and much crafting and much obstruction, what was finalised was a crafting of the target group. It's not a definition, it's not a binding definition on anybody. What it does is it scopes out to states parties who is the target group that should be, whose rights are being protected. So it applies to all persons with disabilities. It includes those with long-term physical, intellectual, psychological and sensory impairments, but that is a non-exhaustive scope. The class of persons protected by CRPD is open rather than closed. So disability is seen as an evolving rather than fixed concept. So it's seen as something dynamic, that it may mean, that scoping may mean something now, but it could mean something completely different in 50 years' time. So the structure of the CRPD, it's comprised of a preamble and 50 articles. The articles vary considerably in density, and it's also the first human rights instrument to have article titles. And being a human rights lawyer, you don't know how fantastic that is. It is, oh, heaven on a stick. And it's not formally divided in sections, but it does have different types of articles. Yep. All right, so the structure of it is that you have a preamble, paragraphs A to Y. And so that outlines the international concerns and highlights key issues for interpretation. So it's basically the antecedents of CRPD. And the preamble is important as part of the interpretive matrix, but it's also important in terms of its antecedents for what it leaves out in recognition of legal antecedents as to what's actually in the preamble. And quite instructively, the earlier declarations are left out of the preamble, along with the 1991 mental health principles. And they were specific omissions from the treaty to move away from paternalistic early constructions around a care, treatment and protection approach to disability, and one that maintained an approach of limited rights. Then you have your main interpretive articles of Articles 1 and 2. Your general obligations are set out in Articles 3 to 9, which give you cross-cutting principles and measures. Then you have the specific obligations, Articles 10 to 30. Now they give detailed specific human rights, they give specific detail to the human rights and fundamental freedoms. Some very prescriptive, some very much just state principle. And then you have the implementation and monitoring elements, Articles 31 to 40, and they set out the arrangements for national and international implementation and monitoring. And then you have the operational elements, so they set out the administrative and legal issues. And then the optional protocol has 18 articles. And as I've said, it's a separate treaty that sets out a communications and an inquiry procedure. So the CRPD is mostly written in straightforward, easy to understand way. That does not deny a level of constructive ambiguity. Trying to get the CRPD done in time, our chairperson was understood, our chairperson understood that if we didn't get it done by the end of the 8th session, the chances of us getting a budget out of the third committee to go on any longer with the negotiations was basically yours and Buckley's. And for that colloquialism, basically we had no chance. And so we needed to be able to get consensus. We needed to be able to agree, and we needed to be able to let go of the perfect for what we could live with. And Don was famous for saying that perfect was the enemy of the good. And so with that came constructive ambiguity. So we were prepared to leave, in the words of Gerard Quinn, wiggle room within the construction of the articles and leave it to the jurisprudence. CRPD rights and obligations will be subject to interpretation and elaboration over time. So we were willing to see a way that articles could be interpreted, but not to be too overly prescriptive about it and leave it to the jurisprudence. So the interpretation, the principal role of the treaty body, the jurisprudence will be developed through general comments, observations made about state parties' reports, and observations made in the adjudication of communications. And this process commenced in 2009 with the work of the treaty body. So, two key principles in interpretation of international, there are two key principles in the interpretation of international law generally. There is the living tree doctrine. The text of a treaty is considered organic, and it must be interpreted in a broad and progressive manner so as to adapt to contemporary conditions. So what it empowers the treaty body to do is to be prepared to see international law as a dynamic thing, as an evolving thing. And this helps, especially in the case of disability, to move away from old understandings of disability and old approaches and give new light, for the want of a better analogy, onto international human rights law. And that should be also lined up with a broad and purposive approach where the text of the treaty is not to be interpreted narrowly or literally. It instead is to be interpreted broadly in light of its underlying purpose. So if human dignity is one of the underlying principles of the CRPD, that is the purpose with which articles should be interpreted to achieve that purpose. So the key interrelationships between categories of CRPD rights, it's dynamic rather than linear in structure. So to ascertain the scope of each specific obligation, it is necessary to consider its intersection with each of the interpretive articles, general obligations and national implementation and monitoring articles. Also, there are important interrelationships between some specific obligations. Implementation action in relation to closely interrelated rights ought to be coordinated. So, how does everything fit together? Where do the general principles sit and how do they influence other articles and obligations? So, can we go to the next slide? So, the intersection of Article 6, women with disability, with Article 10, the right to life. So Article 6 gives you a substantive article recognising that women with disabilities, for women with disabilities, states parties recognise that women and girls with disabilities are subject to multiple discrimination and in this regard shall take measures to ensure the full and equal enjoyment by them of all human rights and fundamental freedoms. Now that's not the beginning and the end of the obligations for women under CRPD. You don't look at Article 6 in isolation to other articles. What should happen is you should look at the interrelationship of Article 6 with other articles, such as, let's look at Article 10, the right to life. So states parties affirm that every human being has the inherent right to life and shall take all necessary measures to ensure its effective enjoyment by persons with disability on an equal basis with others. So then how do you align both Article 10 and Article 6? So when you look at measures that you might be expecting to see from states parties, you might be looking for things like breast screening equipment is accessible for women with disability who use mobility devices, so women can be scanned for breast cancer. Women with intellectual disability are supported to participate in regular cervical screening on the same basis as other women. Or emergency accommodation services for women escaping domestic violence are accessible to all women with disability. So it's looking at measures addressing the right to life, but it is viewing them through an interrelated lens of women. Rogue PowerPoint screen number 1. I normally have more than this far into, presentations, so think yourselves lucky. God knows what the top of that says. It probably says something really, really interesting and you're going to miss out on it. I apologise. So again, coming back to the major themes in interpreting CRPD. So you need to also look at the underlying policy, and you get that from the preamble, as I was saying before, what it identifies as the antecedents that inform the CRPD, but also what it picks up as the major themes. Also, Article 1, the purpose. The purpose sets out, strangely enough, the purpose. That it's there to promote and protect the rights of persons with disability, but it also scopes out the target group. And Article 3, the general principles. So there are 8 core principles that are set out that should be an interpretive tool for each and every substantive article. But also consideration needs to be given to the positioning. So persons with disabilities as human rights bearers. So that should be an overarching position that all measures take, that persons with disabilities are the rights bearers. disability concern as human rights challenges. And so it's recognising that disability, there are barriers to people with disability exercising their human rights, and so it should be about addressing those core policy challenges. But also the underlying theme around a social model. It was a big thing during the convention negotiations that this was to approach a social perspective of disability rather than harking back, going back to some of the earlier instruments that were very much couched in care, treatment and protection, or what gets adopted as a medical model of disability. So this is recognising that disability results from persons with impairment attempting to interact with a barrier-filled environment, and that has an action implication to dismantle barriers to full enjoyment of human rights, and that state obligations almost exclusively focus on the removal of barriers. So the general principles, or the core foundation values, to guide and underpin CRPD interpretation and implementation. So respect for the inherent dignity and the right to autonomy and independence, respect for difference and acceptance of impairment and disability as part of human diversity, the right to inclusion and participation in society, the right to equality and non-discrimination, the right to an accessible environment, and the right of women and girls to equality, and the right of children and young persons to recognition of their specific needs. So those 8 principles should be filtered when looking at the interpretation of specific articles as well. So obligations that must be taken into account in the interpretation and implementation of each specific obligation. So consideration needs to be given to what the general obligations to the States Party are, and they're set out in Article 4. And important for civil society in that is Article 4.3. 4.3 sets out the need for States Parties to consult with people with disability and their representative organisations. Article 5, how the right to non-discrimination is being protected as it relates to a particular substantive article such as employment. Is there a right to the protection of is there protection of the right of non-discrimination in measures taken under certain articles? Article 6, is there a focus for women and girls, or a gender perspective taken through implementation measures? The same with children with disability. Does the government do anything around raising awareness around the issues raised with each substantive article? Is there accessibility in employment measures, in measures for health? Is the government collecting disaggregated data and compiling statistics to inform policy implementation and policy development? And is there a national implementation and monitoring mechanism that incorporates the people with disability and their representative organisations, and also includes the work of national human rights institutions? So what are the levels of obligation? Recognition of the treaty, so it must enact laws and develop policies and programs to give effect to CRPD rights. The respect of treaty rights, where states parties must refrain from action that arbitrarily interferes with CRPD rights. And to protect treaty rights, states parties must prevent non-state actors from arbitrarily interfering with CRPD rights and fulfil treaty rights. States parties must take positive action to ensure that treaty rights are realised in fact. So we'll just have a quick look at this in terms of the right to life. So recognise what measures may be taken under recognise. So enact legislation incorporating the right to life, including its CRPD elements into, for example, in my country, Australian law. Combat negative social attitudes that view the lives of persons with disability as less valuable or less worth living than others. How might states respect the rights? So measures might include abolish the death penalty or strictly control state security forces, army, police, prison officers. How might they protect the right to life? Enact laws prohibiting homicide. So the disability dimension of neglect, so making it homicide, whereby people who have by omission neglected nutritionally or otherwise, and people with disability have died from it, so making that an unlawful process. Enact laws prohibiting discrimination against persons with disability in the provision of medical and health services. And fulfil, ensure that public health measures such as tobacco control and nutrition equitably target persons with disabilities, so persons with disability can access the information. Establish policies and programs to meet the specific health needs of persons with disability. So the cross-cutting obligations, so the standard of obligations, civil and political, traditionally it's been seen as a hierarchy of obligations, that civil and political rights were seen as immediate compliance upon entry into force or treaty, and that economic, social and cultural rights were a standard of progressive realisation over time. Now, progressive realisation is not merely aspirational or unsustainable standard. An obligation, all obligations under the treaty are immediately realisable to the maximum extent of resources available. So obligation to take progressive action is immediate. It can't be indefinitely delayed, or you can't fail to take action and say that we will ultimately progressively realise it. Action must be immediate and it must be continuous. Regression is not permissible, and it must take action to the maximum extent permitted by available resources. And that will vary from nation to nation. But the action doesn't necessarily have to be something that is a resource impost. It could be just starting to make explicit policy positions. So it could be cost neutral. But it must include targeted steps and a projection of measures that will meet the obligations over time. Implementation measures must be equitably distributed with a focus on the most disadvantaged. Yep. Each article deals with a specific subject matter. Some articles have multiple elements derived from existing human rights. But specific applications of those rights, so affirmation of existing rights with respect to persons with disability, So Article 10, the right to life. Affirmations of existing rights and disability-specific measures. So Article 12, equal recognition before the law. So it states the affirmation of the standard of equality before the law. Then it goes on to give specific prescriptive normative content to the article from a disability context. Or new specific applications of traditional rights, such as Article 11, situations of risk and humanitarian emergencies, where it introduces new material to a human rights treaty from a disability perspective. And there are 20 substantive articles. 15 are seen as traditionally understood as civil and political rights, and 5 economic, social and cultural rights. I think we're just about done. There's a list of the civil rights. So as you can see, some of them present as traditional forms. Oh, Jesus. Excuse me. Well, it sounded like me. Oh, that's okay. Turn around. You're being told. So articles such as freedom of from exploitation, violence and abuse is not something that you'll see in either of the covenants or the other thematic treaties, but it does come up within articles and jurisprudence, especially from the Convention on the Rights of the Child. And liberty of movement and nationality is seen in other instruments from a very different perspective in terms of immigration and state recognition, to being very much about civic duty and detention in, I was talking about Article 16, freedom from exploitation, violence and abuse, not liberty of movement, my apologies. Personal mobility picks up something that's not found in other treaties, but relies on the framework of liberty of movement to be able to keep it within the traditional human rights framework. Okay.
I'm
Just-
going to have to call time on you now.
Can I just go to the very next one? I thought it was. So as you can see, there are 4 areas of rights: it's political, economic, social and cultural. And since I've gone through this at a rapid rate this afternoon, I do apologise. These slides will be available from the Dropbox if we're still using the Dropbox. Mm-hmm. Thank you.
Okay. Thank you very much, Rosemary, and I'm sorry for rushing you. I hadn't realised that your presentation was as long until we started. So I'm going to call on Professor Quinn now to come before we break up for coffee, because directly after coffee, you're all going to go into the breakout rooms. And just to let you know, on the back of the, Marco for a moment, on the back of the doors outside, your names, can you show me that page? Yeah. Your names will be up. There will be 4 breakout sessions in different rooms. Breakout groups will be posted in the lobby at the next break, so that's just coming up now. There are also on the school's OneDrive. So those of you who are connected into the OneDrive as well. Now, just before we break up for a thing, I've asked Professor Quinn just to talk a little bit about the workshops.
So, I guess everybody is a bit tired. The idea behind the workshops is people in successive summer schools said not enough time for us just to interact with each other. So we're setting aside at least an hour every day for that to happen. And what we want you to do is reflect on the proceedings during the day. You might be able to relate to it, you might not be able to relate to it. There might be issues that you consider more important or less important. We don't care. It's just to give you space to reflect aloud with each other, and you really are the experts. The people speaking are expert enough, but you're actually really the expert. So that's the idea. And what we'd like to do is each morning we come back to hear from the four groups. And it might just be 2 sentences or 3 sentences. That's all we need. We just need some feedback on your discussion. What was the center of gravity of the discussion? What conclusions did you reach, or were you, divided amongst each other, and so on and so forth? We have 4 volunteers. We're going to quote unquote facilitate, i.e. start the discussion. I'm not sure that's even required because you'll have so much to say. But they will be there in any event if you need their guidance. And as to who's in which group and where the rooms are, I believe that's posted outside in 3 or 4 different locations. So if you have a problem finding out, just ask one of our volunteers in the purple T-shirts and they will tell you that. So you'll have to appoint among yourselves somebody who's going to come back the following morning and give the conclusions of your group for the benefit of the entire class. So I really hope you've enjoyed the day. Thank you so much, Martin. Martin deserves a huge round of applause. Martin is one of the pioneers of community living in Ireland and in Europe. He's the co-chair of the European Network for Independent Living and a frequent visitor to the land of the free, the United States. So I'll leave it at that. So if you go outside, you should be able to see your name in lights, your name up in one of the posters, and have a good time, a good discussion. And see you tonight at 7 o'clock in the Radisson for the party, okay?
I think we can get